So hi everyone. I am chairing the second panel of the day. My name is Raj Jagdev. I'm a partner at Powell Gilbert. We're a boutique patent litigation firm in London. Thank you. London, Dublin, and Dusseldorf. I'm joined on this panel today. The panel is about UPC statistics and updates. And we have a distinguished panel of European practitioners and, of course, Steve at the end. So to my right here, I have Marc Lauzeral from Cherson-Lieb. Marc's based in Paris and has a practice focused on cross-border patent litigation, SPCs, and trade secrets. He has experience for the French, German, and Italian divisions of the UPC, and, of course, the French courts as well. Then next to Marc, we have Yasmine Azzaoui and then Carl Dinges, both from Bonnarbury. Carl is based in Munich, and his practice is focused on high-tech patent litigation and sub-brand litigation. And Yasmine is based in Paris, and her practice is focused on life sciences and pharmaceuticals. And then at the end, we have Steve Carlson from Robbins Kaplan. Steve's based in Silicon Valley, and is a seasoned IP litigator, assisting clients with IP disputes both in the US and internationally. And Steve is the co-author of a book called Patents in Germany and Europe, Procurement, Enforcement and Defense, together with Alexander Hargath, the other co-author who you'll hear from later. So this panel is going to look at the stats that we have available about the UPC so far. But I'm going to start with a health warning because we don't have great statistics. So we have a comprehensive case management system which collects a lot of data, but that data isn't made available to practitioners or to members of the public. The UPC does publish an annual report, and it published its first report for the year ending 2024 in June of this year. And
did you say the data is available for the public?
Is not available. It is not available. So it's something we're working on. There is a limited set of data available, and there are other resources which I'll get onto. So Docket Navigator, for example, has a great UPC dashboard, and Docket Navigator you guys use quite widely already. It's relatively new in Europe, but it is a great resource for certain UPC statistics. And a lot of firms like ours collate our own data, and so judgments and orders are public, and so by parsing those, you can develop your own data set. And so the slides and graphs I'll be showing you today are in part derived from Docket Navigator data, in part derived from our own analysis. And therein comes a health warning. And so they're as accurate as we can get them, but they shouldn't be relied on. They're for informational purposes only. The UPC report is a fantastic resource. If you're new to the UPC, it has a set of stats at the end, but it also has a summary of the key decisions up until the end of 2024. So it's a good introduction to the court and can help you get up to speed. But of course, the court has been very active since the end of 24. We've had a lot of decisions in 25 that have helped to shape the case law. And so you'll want to top it up with more current reports. One of the key issues, and Marc, I know this is a bugbear of yours, is the way in which the UPC counts cases, and that feeds into some of the stats that you'll see presented. Do you want to talk a little bit about that?
You know, it's actually really simple. Every time you have an order or you are making an incident proceedings, it counts as a proceeding. So sometimes you're going to get one case. Sometimes I know cases when they enforce 5 different patents. If you are filing for a request for confidentiality information, so you're going to have 5 at the beginning. You had 5 proceedings which was counting for the invalidity for the infringement action. Then 5 for the content claim for infringement. Then 5 for if you request for confidentiality of information. So at the end of the day, you have this huge amount of number of we have 1,000 proceedings, but it does not mean that you have 1,000 cases. So that's where the struggle is.
That's exactly right. And so we go to a lot of effort as practitioners to try and devolve down to the number of unique disputes. And so the graphs that we'll see today show the number of unique disputes as best we can determine that. So I thought I'd start with a bit of a sneak preview of Docket Navigator just to help you orient yourself to the extent that you want to find a useful data source comparable to what you have for US litigation. We're not sponsored by Docket Navigator. They're not funding this, but it is just a great resource. And so there is a UPC library that's available, and you can see on the right of the screen the sources stats that are available. There's a very good dashboard with graphs and statistics, and you can also get access to decisions and orders and opt-out information as well for the prosecutors in the room. So I thought the UPC report would be a good place to start. And so these two graphs are taken from that report, and they show the number of actions brought, and the graph on the left focuses on revocation and infringement actions, and then the average time to trial on the right. And what you can see from the trend is that the number of infringement cases has steadily increased month on month, and it shows just how popular the UPC is proving. It really has taken off in a remarkable way, and the court is quite busy. And we'll go on to see some stats about which divisions are the busiest. But the time to trial slide on the right is quite interesting. So one of the key promises of the UPC is trial within 12 months. And what we can see from that slide is that the average time to trial for an infringement action is actually 405 days. So it's slightly over the 12-month limit, but within an acceptable margin of error. And so by and large, the UPC is delivering on that 12-month timeline. Whether that is still the case at the moment remains to be seen. The next version of this report will be published later in 2026. And certainly our experience is that some of the divisions are busier than others and perhaps aren't quite getting to trial in 12 months. But Steve, I thought this would be a good opportunity to bring you in to talk about how this compares to litigation in the US, both in district courts and also the ITC, which I think is perhaps the most comparable time-wise to the UPC.
Yeah, I think that in the US, the fastest you'll get to trial is the ITC. You'll get your initial determination in about 12 months, and then your final determination about 16 months. So that's the fastest you'll get, which is roughly on pace with the UPC, a little slower. But if you go to district court for damages, et cetera, really Texas, you're into 2 years, and it's up from there. I'm in a case now. It'll be more or less a 4-year timeline. It had a PTAB challenge in the middle, which slowed things down. So really, you're looking at 3 to 4 years in the U.S. compared with a 12-month time to trial in the UPC. It's night and day. And like Wayne said, it's on the development cycle. It's in your product development cycle timeline. So I always tell clients to consider the UPC because it's so much faster.
So the next slide is taken straight from Docket Navigator. So this is quite current. It's as of the end of October this year, and what it shows is the usage across divisions, and you can see that by quite a mile, the German divisions are the busiest, with Munich being by far the busiest. I think the number there is it's slightly blurred, but it's 1,197 unique cases or filed cases, not number of unique cases, but it correlates to also the largest number of unique cases filed in Germany. And this is a great opportunity to bring in our European panel members. Because Yasmine, Marc, you're in, of course, based in France, in Paris. And Paris is also quite popular, but the German divisions have really taken the lead. Do you have any perspectives as to why that is?
So I think historically is due to the fact that French, and it's going to be, I think, the same thing for the Netherlands, are really close in their judicial system to the UPC. It's the fact that you have more proceedings in Germany does not mean that the food is better there, or sometimes you may have local division which may be a bit more pro-patent in the south of Germany. But apart from that, what happened is when the UPC was launched, when our client came to see us and they say, okay, what should I do? Should I launch before national proceedings or before the UPC? You will say, look, UPC is going to be the same thing than French proceedings. It's going to be 1 year and a half, so a bit longer, but 1 year and a half proceedings to get a first instance decision, 2 months for a PI, well, you're going to discuss validity and infringement. The only thing which will really change is the fact that you will not be able to file auxiliary request. So you're going to say to the client, UPC, it will only give you uncertainty because we don't know where the things will go. It was the same with the Netherlands, but in Germany, I think the system is really different. As you get a bifurcated system, when you're going to deal with one proceeding only relating to validity, one proceeding only relating to infringement, the UPC offers a true alternative. And what we have seen more and more is the fact that in Germany, you had a transfer from national cases to the UPC. You had seen the number of national cases decreasing, and now we didn't have that in the first year in France and the Netherlands. For instance, the UPC cases were additional layers, new litigation. And now we start to see that, I think, from the past 6-7 months, when you have in France close to 20% decrease in the number of national cases filed before a national court. I heard from a colleague, I don't know if it's that high, but he told me like 60 to 80% decrease in the Netherlands. And so now you start to have that. So I think the new proceedings, the Paris local division and even the Hague local division, when discussing with Brickman, Judge Brickman, that's what he told me, they are starting to get there. So I think you're going to have a more equilibrated system with maybe still the Germany will be important. And I think it will also really depend on some, but we will talk about it later, I assume, some industry. The Germany is better for France historically because you're going to have more certainty on their case law.
And that's right. You made a very interesting point about the transition from national actions to the UPC. And Carl, in Germany, of course, quite a few of the national court judges have moved over to the UPC. Is that a factor that plays into the popularity of the German divisions?
Yes, I think so. So practically even before the UPC was established, but by far the most cases have been brought to Germany, and that was at that time probably because of the impact and it was just the biggest country, and we had this bifurcated system, of course, which is a benefit to the patentee. And when the UPC was established, there were 4 local divisions which are still there located in Germany, and all of those local divisions have been assigned with judges from Germany. And there's a quite interesting provision in the UPC agreement saying the constitution of the panel depends on the number of cases which have in the last 3 years been litigated in that specific country. And if that number is below 50, then there will be 1 national judge in the panel. And if that number is above 50, then there will be 2 national judges in the panel. And therefore, in all those German divisions, you have panels with 2 national standing judges, which makes the predictability of who is going to be your judge very high. And there's a big, just a huge room for forum shopping, because you know who is going to be the judge deciding on the specific question of the case to quite an extent. I mean, currently, since there have been quite a lot of cases, this has changed because there are further chambers assigned to the local divisions, and but right at the beginning, I think it was quite interesting that you could, on a case by case level, say this is a case which I would like to bring to this or that local division because I know at least 2 judges of a panel of 3 legally qualified judges and plus 1 technically qualified judge.
The panel, talk about the judges a little bit. Are there hundreds of them, thousands of them, like in the U.S., where hundreds, where it's very diverse, or is it more specialized in smaller groups?
No,
you're getting patent judges.
It's quite specialized. So there will be right at the beginning there were only at the local divisions there was only 1 chamber with the national judge or the 2 national judges being standing member of that chamber, and then there was a pool of the European pool from all other nations, which would bring in the missing third or second and third legally qualified judge. And I think that pool is on the legally qualified members is about
44 now.
44 now, so it increased a bit. And in addition, there's a pool of randomly assigned technically qualified judges, which is a bit larger, I think, but I don't know the exact number. So it's rather, yeah, you could know about some of those judges.
And of course, when you say randomly assigned technically qualified judges, they're assigned based on their technical ability, but not necessarily based on nationality, which does play into the assignment of legally qualified judges to cases. Do you want to say?
Yeah. Just wanted to add something. Considering the concentration of the cases before the German local divisions, we need to consider also what will happen after the end of the transitional period. So for now, there is a dual jurisdiction of the UPC and of national courts regarding European patents that have not been opted out, and so after the end of the transitional period, which should be in 2030, it can also be extended by another 7 years. So we still don't know what will happen. But after the end of the transitional period, the UPC will have exclusive jurisdiction on those European patents which have not been opted out and the new European patents that have been granted. So there is a need to have a more balanced system with like a number of cases that is balanced between all those local divisions. And it would be interesting to bring more cases before those local divisions that have not many cases right now. I'm not talking about France, because France is getting more and more cases, but more, for example, the Lisbon local division, the Nordic Baltic divisions, to like gain more experience and take more decisions.
Maybe just a quick one on that as well. It also extremely industry dependent. When you are looking at SCP, like I said, you have a lot in Germany. When you are looking at life sciences, you've got, I think, almost 60 patent cases which has been litigated, and they are in front of 10 different local divisions. So you have people in Lisbon, you have people in Paris, Düsseldorf, Milan Central. So it's really industry specific.
And Marc, do you think that's because of what Carl said about the predictability of the judges? And then is that perhaps working against those predictable divisions? Because, of course, we see Munich being quite overutilized, and that leading now to delays in the conduct of cases there.
I think that there is a tricky thing about predictability, because I know that from the US, a lot of US colleagues told me that Europe is now kind of Wild West, like we don't understand really what is happening here. But regarding predictability, you know that, for instance, the Munich local division has a president who was really extremely open about the fact that he was pro-patentee. The only thing is, like it was mentioned, it's 1 year proceedings to get a first instance decision, less than a year to get an appeal decision. When you are looking at the overturning rate of the president of the Munich court, 2 decisions out of 3 are overturned. So it means that now, if you want to get the most relevant decision at an earlier time, I would not recommend to go before the Munich local division. While when you are looking at the other local division, except the German one decision out of 3 is overturned. So when you think about predictability, you're going to say, okay, for maybe this judge, I will have predictability. But when you are looking like the next 2 years, actually, it will not give you predictability, because you're going to say, oh, I've got a winning decision, but what will I do with that? Because even the defendant knows that he's going to have better chances of success to overturn this decision. So I'm not sure that predictability is more like a German thing.
Yeah, but it's a sort of short-term predictability based on experience of the judges in national proceedings. We don't have enough time in the UPC yet to be able to develop predictability within the court there. Did you want to come in, Carl? Or?
And I would just like to make one statement. I don't think it's so. I'm not quite sure whether this 2-on-1 rule is actually true for the merits of the case when it comes to the patent infringement, but rather there have been, of course, it's a bit of a clash of cultures, and that's what one needs to understand, that there are so many judges coming from so many different jurisdictions that they look at the same question, and particularly on procedural questions, from different angles and through different eyes. And that's why I think at the beginning there have indeed been some decisions that have been overturned. But I think the predictability when it comes to the finding of patent infringement is still quite, at least in my personal opinion, is quite high. I don't know the exact number on that, but.
So you mentioned culture. That takes us neatly on to our next slide. Language of proceedings. So one of the consequences of the German divisions being so popular early on is that at the start of the UPC, most actions were filed in Germany, and there are other reasons for that, around selection of languages and formal designation of English as a language in certain courts. But we've seen that shift quite materially over the years now, over 24 and 25. Now, the majority of cases, just over half, are conducted in English, and certainly the judges, the UPC, and we're going to hear from two of them later on, really promote English as the language, and that is to make the course as accessible as possible to users. And Steve, this is a good opportunity to bring you back in on accessibility, because there is a cultural difference between the UPC and its predominantly procedural or civil law approach to litigation versus what you're used to in the US as a common law jurisdiction. And we'll come on to other common law flavors in the UPC as well, but maybe you want to talk a bit about language first.
Yeah, I mean, there's a lot of the litigants there are American, right? We are either being sued over there or we're bringing cases there, and here we speak English. And patents are really funny documents with very intricate languages. We pushed the English language to the max. And when you construe claims, so much hinges on just these little nuances of language. And you want your panel to understand it. You want your panel to really understand English at a native level. The courts have been sympathetic to requests to move the language to English. If it's filed in Germany, there's a lot of motions to have it heard in English. Those tend to win. There's sympathy for the defendants being hauled in there, that they should have their own language being used. A lot of eyes are on Ireland. Ireland's not in yet, but I think if Ireland gets into the UPC, that could be a very hot jurisdiction, because you want to be able to relate in the English language to your judge who grew up with English, not as a second language, but as a native language. And so I think we're all looking at Ireland as possibly being a very hot jurisdiction if they get the rat together, if they get online.
I think that's a really good point about Ireland. Terry's still in the room, but to answer her question about the UK joining the UPC, I mean, there are issues around the way the UPC agreement is drafted that are perhaps a barrier to that at the moment. But the second best option is Ireland. Ireland being a common law jurisdiction, and so it has a tradition of disclosure and expert evidence and discovery. And it's important to note that the UPC rules actually do allow for some limited discovery. And so Rule 190 of the Rules of Procedure allows for specific disclosure of documents. And so that's an underutilized rule, and that's partly cultural. Certain courts, certain jurisdictions, because they don't have a history or a tradition of discovery, don't really understand the utility or don't entertain it. But there was one case in the Hague Local Division where a claimant was able to get some limited discovery in relation to an integer that they couldn't make out without looking at the proprietary documents or the confidential documents of the defendant. And so they were successful in getting an order for discovery. They lost in the end, but the principle at least is banked. And perhaps having a jurisdiction like Ireland, a division in Ireland that has a common law background, but might see more Rule 190 applications being made and granted. And certainly in Germany, Carl, they are used for SEP-FRAN cases, right, to facilitate disclosure of licenses in that context. And just on the English point, it'd be great to hear from the three of you as to how you sort of feel about litigating patents that are in English, but in French or German. You made a very good point, Steve, about the detail of the language and nuances, particularly in the context of technical disclosure.
Well, yes, if I may start. So, interestingly, currently litigating patents, English written patents in English before the UPC courts is not as litigating before a native speaking English judge. And it's something that the judges make very clear themselves that they would like the parties to lower their English level when they address specific questions, because all of those judges have a tradition of working in their specific native language. They have not, unlike many of the lawyers in the countries, have not dealt directly with international clients, and therefore had a part of their work being originally made in English. Although the skills are very high, I would say we are at a very good level, and the judges do speak very, very good English, and things are very go very well. But they address this question that, for example, bringing in a native-speaking witness can be some kind of difficulty, because if one, if there are nuances in what the witness is saying, which are not understood by the audience, that's something I would consider, and rather opt for someone also being a second language speaker. And I must say, I would have an issue with litigating a French patent, and I would always try to bring someone in from the original language who is co-counseling or even first chairing the case, because it depends on the specific language skills you have yourself. I wouldn't be comfortable with doing that for French patents.
Yeah, I think there's going to be in France, from what I've witnessed, the only case you have a case in French is that the patent is in French. But usually the court are really, really open to change language of proceedings if the defendant is an English-speaking party, or a UPC representative are English-speaking. They are really open to do that. I think that all judges, some have been in private practice even, so I would say that they speak very well English, to be honest with you. I know that, for instance, Judge Camille Linière in Paris, you're going to hear this afternoon, and with Judge Grabinski, both will address the question of UK and Ireland, so I just want to make a little teaser. But Judge Linière lived in DC for 2 years, so they understand. Of course, it's not up to what a UK judge will understand, how the same thing that the UK judge will understand with a barrister, but I think the language barrier is not that difficult, to be honest with you.
I think conversely, it's slightly harder for a native English speaker, because it is very much European English that's used. Yes. And so using our idioms and colloquialisms often gets lost in oral submissions. And so there's a bit of adjustment for native English speakers to actually properly advocate and get their points across to a panel of non-native English speakers. And again, that's where a panel of Irish judges may change things somewhat, but still, by and large, most of the judges in the pool will be from other jurisdictions. And so adjusting the style of advocacy is important in the UPC. It's not dissimilar to the EPO, I expect.
But I must also say there has been a long-standing tradition in Europe to bring different languages together and then speak in French and German and English because of the EPO. Because in the EPO, there have always been procedures with panels from many different countries, and they always they were obliged to speak those three languages which are spoken at the EPO. And I think it turned out quite good. So although the English is not as you would expect it in a patent trial in the US, it is perfectly good to litigate in the UPC in English, although there is no native speaking country being English speaking
At the moment.
at the moment.
So while we're talking about trials, you highlighted, I think, Mark, that it's a one-day proceeding. And so it is very different in style to what we're used to in the UK, where a typical patent trial will be 4 to 5 days, or in the US, where it'll be even longer. Do you want to talk a little bit about the nature of the proceedings and how they're conducted?
So you have a written part and you have an oral part. Usually the judges are making some kind of pre-deliberation before the trial hearing. You're going to have an interim conference when the procedural judge, the judge rapporteur, as we call it, will say, okay, I want you to advocate on this point, this point, this point. Then you're going to have a one-day trial hearing, and it's going to be really, I must say, from my experience, you can discuss patent for like 4 or 5 hours long, just purely with UPC representative making 1 hour advocacy. Then it's question and answer. So you're going to have, what is good with this type of question and answer thing is you gain more predictability in a way that you can address some issue. Sometime before national court, you are making 2 hours advocacy, then you get a decision and you say, okay, I mean, the judge clearly thought about something we never thought of. So it's a bit surprising. Here, you know where kind of, you have the feeling where the things will go. And you have like it was mentioned sometimes the possibility, but it's extremely limited to hear some expert, either through from the Nordic Baltic division, a UK style, but it's only limited to 30 minutes.
Yeah.
From what I understand, or like what you get in Munich, how do you call it, a hot tub of experts when you are making just the expert discussing between each other. So yes, so it's just a one-day intense trial hearing when you have to be really straightforward in your argument.
Quite focused.
Yeah, exactly.
So the slides up at the moment is nationality of parties, and Steve, you already mentioned that the US parties are the second largest group in the UPC already, both on the claimant side and on the defendant side. And so I think it just highlights that the US is already in the UPC, whether the parties like it or not. On the defendant side, probably they're not so much of a fan of being in it. But there are also quite a few infringement actions commenced by US litigants. And I think we have a panel coming up later of in-house people who have some UPC experience, and I think they'll be able to talk a little bit more about their experience of being in the UPC and the various divisions and the way in which hearings and the procedure generally is conducted. So one of the great things about the UPC is the availability of preliminary relief. And so you can get preliminary injunctions and other preliminary measures like seizure orders, and that is unique compared to the US, as we heard on our earlier panel. And the grant rates are quite interesting. So, based on our analysis, around a third of all, or just over a third of all PI applications are granted, and then a further third, or just over, or just under, granted in part. And so that's a pretty high hit rate. Now, this isn't just for preliminary injunctions, it also is for seizure orders, and that's a tool that's often used on the continent to gather evidence before filing a substantive claim. Yasmine, do you want to talk a little bit about this?
Yeah, of course. It's really interesting to see that first, most of the PI cases are concentrated before the Düsseldorf and Hamburg and Munich local divisions. Today, in terms of volume, PI cases represent approximately 20% of all the UPC cases filed. And the average time to close a PI case is quite quick. It's approximately 96 days. Before the Court of Appeal, the picture is quite balanced. So today there are about 50% of the first instance PI decisions that are overturned by the Court of Appeal and 50% that are confirmed. But this number will certainly be reduced with the time because the Court of Appeal of the UPC is building its case law. And when we see the statistics of the reasons for refusal of granting a PI, most of the reasons are based on an insufficient degree of certainty of the validity of the patent or of the existence of an imminent infringement. And we can also notice that there are common procedural approaches between the local divisions. The local divisions are trying to limit the number of arguments that are brought by the applicants. For example, the Munich local division has already said that the applicant must only bring like 3 arguments maximum. The Paris local division has also required that the applicants summarize their submissions before the Paris local division. And we also see some minor differences in interpretation before the various local divisions. This is essentially concerning the requirement that the applicant must demonstrate that he has acted diligently after being aware of the existence of the infringement. So, for example, the Düsseldorf local division stated that only 1 month is sufficient after being aware of the existence of the imminent infringement, whereas the Milan local division expressly departed from this and considered that 2 months can be sufficient to file a PI action after being aware of the infringement. So there are some minor differences, but like today, the most of the PI cases are still brought before the German local division, and it will be great to file more PI actions before the other local divisions, so as to build like more case law and to have more experience.
I think we have a question.
So Raj, just to clarify, what's the x-axis? So it says, okay, 1/3 PIs are granted. That's significant.
Yes.
But
number of decisions.
So there's only been 8 requests for PIs?
8 requests in Hamburg, and so you have to add them up. So it's by division, and so it scales up. Do you have a?
But the next, as you do the next 2 slides, the numbers just seem. Are the cases just not? It's too soon for them to have decisions because we saw that earlier slide where they're filing like 200 cases last month.
Yes.
So they're just too soon in the process.
That is what I mentioning earlier, given the folk screen of number of proceedings. When you are discussing cases, there are some you get more and more predictability. Now you see where it goes, but it's not like 1,000 cases. That is, I think, pretty eloquent what you just mentioned here.
So what we've done in these slides, in the next 3 slides, we have collapsed down into the number of unique disputes. And it may be, for example, if you have 3 defendants in a particular action and you file a PI, well, that will count 3 times for each of the claimants. If you have 2 claimants in that, it'll be 6 times in the official UPC count. But really, it's 1 dispute between 2 parties or related parties. And so what we've done here is collapse down to unique disputes rather than just a number of pleadings filed.
So slide 3, 4, and 5, where you had numbers in the hundreds.
Yes.
Or the
Those?
Increase, those are motion kind of decision and stuff, not actual unique cases.
Not unique cases. That's right. So the UPC report slide. So this and then the blue background ones are the number of actual pleadings filed. Essentially, that's the.
Why? They've been in business for a long time. There's a difference between a motion and a case.
There is a whole panel discussion to be had about the IC of the UPC and the deficiencies with it. That things are improving. Docket Navigator does a good job, for example. Of it ought not to be that hard. It ought not to be that hard, but it's proven difficult for the guys.
The patent stuff's hard. Counting the number of cases shouldn't be that hard.
So one of the big changes this year to the UPC is actually a move over to a new system built by the EPO. So things are better, and we're hoping that we'll get better quality data as you do for EPO proceedings out of the the new system. So the next time we have this this UPC day, we ought to have some better, more accurate data that's aligned with the UPC official statistics. But for now, we leave it to the market to come up with the data, and there are various sources. So,
Raj, I wanted to ask a question, just kind of put things in context. How long duration of time from filing to an enforceable preliminary injunction?
that is a very good question. So before I answer that, it's helpful to set the time frame for the written procedure for a proceeding on the merits. So the written procedure takes 8 months from start to finish. For a preliminary injunction, collapses right down to around 2 months, 2 to 3 months, which is incredibly condensed. And so that is the application for the injunction, and then the defendant will have an opportunity to make non-infringement arguments and also raise any invalidity arguments. That's quite, and so you have about 4 to 6 weeks to pull that all together. So there isn't very much time at all to do that, and you're probably going to be faced with a proceeding on the merits at about the same time. And so you're having to fight on two fronts. The system is very much weighed in favor of the patentee claimant at the moment, given the front-loaded nature of it. It puts an awful lot of pressure on defendants to act promptly and quickly and efficiently in responding to applications or for PIs or even substantive infringement claims.
So the follow-up piece to that question is, in the U.S., if you hear about preliminary injunctions, it's like Bigfoot. I'm not sure that I've seen anything other than pictures of them in a decade. But they theoretically exist, but then they come with this enormous hammer of having to post a bond, which could be tens or hundreds of millions of dollars. Is there anything equivalent that you have to post for the UPC?
Do you want to say?
Yes, there is. There is a large discretion for the court to post a bond for preliminary injunctions. And I think it would depend on the industry. So going back to what we know from the national patent litigation, in very many cases there is no bond in place as long as you believe that the applicant is able to ultimately recover for damages which incur based on the injunction. And for example, in originator generics cases, there would not be a bond for the injunction. And obviously, in an NPE case, the NPE requesting for an injunction against a large company being active on the market, there would evidently be a huge bond recovering what is at stake. But the requirement to actually get a bond is that you produce evidence on the damages which likely occur based on the preliminary injunction. And that is something which companies usually don't like. So it's still you need to get into a discussion at what height should a bond be placed. But even if you don't want to disclose everything, I think there's ways to establish facts that there should be a high bond. Yeah.
Sorry, I have a follow-up question. So if the bond or estimate of damages is large, that kind of suggests that the harm caused by the injunction is irreparable. And if there's irreparable harm being caused by the injunction, should that factor into the balancing of interests when considering the grant of a PI?
I think yes, it should. And I don't really have the statistics on whether there is cases in which the injunction was based on this aspect which you raise not necessary. So ultimately, the question whether an injunction is issued is whether there will be irreparable harm for the claimant if it's not issued, which is something that would be taken into account. And therefore, in those situations where you don't actually protect a certain market, and you cannot show there's damage for you, it would be quite an obstacle to get a preliminary injunction.
And actually, sorry, Tom.
No, do you have experience with that? Have you seen injunctions in?
I don't, but what I was going to say is that there is an effort amongst the judges to dissuade parties from seeking preliminary injunctions because of the burden they place on the court. But it doesn't matter because you can get to a final injunction within 12 months. And that takes us on to our stats on infringement. So the infringement outcomes in the UPC are also quite interesting. So just over half of all infringement claims lead to finding of a valid and infringed patent. Carl, do you want to talk briefly about this slide and the success or the stats for various divisions?
So I think this is a significant finding that over half of the cases are found to be infringed and valid, the patents to be infringed and valid, which significantly differs from what we've experienced in national courts. Although we had quite high rates of infringement findings in Germany earlier, we also had a high rate of invalidations of patents, and there was an injunction gap. Several cases have been settled, but I would say by large we didn't have that high overall success rate. What is interesting also is that if you look at the different local divisions, the tendency is roughly the same. I mean, of course, if you if the caseload is too low, you cannot really take too much out of the numbers. But also in Düsseldorf, Munich, Mannheim, and Paris, it's roughly it's roughly about 50% of the cases being held infringed and on valid patents.
So, Steve, very quick, I'm conscious of the time. How does this compare to the US?
Well, I know that for patents trying to survive the PTAB, at least as of 2024, now it's vastly changed over the last few weeks even, but it was only about 1/3 of patent claims were surviving the PTAB. And then you got to survive the district court and find it infringed. So it was a very small percentage of people actually winning in the US compared to this slide, which is, over 50% of claimants are winning. So, going back to Wayne's point, faster, cheaper, better, stronger. I mean, you're way better off from just running the odds in the UPC.
Great. And to finish, we do have a slide on validity as well. Marc, if you want to talk briefly about this.
I don't want Richard to be angry at me, so I'm going to be super quick. Just to mention that maybe compared to national court, the interesting thing here is the possibility to have a patent valid as amended. And you can see that the figures are really high. And I think that the ability to be able to amend the patent directly before the court, which is usually not a possibility before national court, allows, or strictly limited, allows for your patent to survive the proceedings. And the fact that it's the same proceeding usually as the infringement, you will not lose, you will not have any squeeze argument when you're going to lose your right of infringement. It's a good thing for the patent.
To amend the patent years after it issues?
Yes. Yes, completely. Completely. And that's the tricky part when you have a patentee, because you have a huge front-loaded system. You are kind of limited in your argumentation. But if you have to defend several set of claims, and when you are thinking sometime about, like, for instance, in the life science industry, things when you have huge application with different therapeutical indication, dosage regimen, everything, you can have a really upper hand when you're the patentee.
But you get only one bite in the apple. So you can amend it at the stage of the reply to the statement of defense, and that's it.
If I may, a quick follow-up on this. So how does this work in a BSH long arm model? You've got an infringement allegation for, say, Spain, in your UPC case? And how do you get to a valid as amended patent when the Spanish court has exclusive jurisdiction over the validity of the patent?
I think you're going to have to apply in any way Spanish law due to BSS decision. So if the Spanish law does not authorize that, then you're going to have to say there is no infringement. But that's my top of my head reasoning.
So I expect BSH will be covered on your panel, Ari, at the end of litigation strategy. It's a new twist on European patent litigation with long-arm jurisdiction and opens up some interesting possibilities. Are there any other questions?
Just one quick question regarding this concept that you can amend the patent during the process. Is the patent amendment in the tribunal or back at the
Tribunal.
So can you repeat the question so we get it on tape? It's such a good question.
So the question is, are patents, is the patent amended in the UPC, in the tribunal, or back at the EPO? And the answer? At the tribunal.
UPC. Yeah, at the tribunal.
I'm a judge from IP High Court of Korea, so perhaps we have very similar patent system as many European countries. So this amendment can also be appealed to the court, and the court decide on whether we would affirm that amendment. So the amendment is limited to fixing obvious errors or limiting down the scope of patents, and the patent holder cannot add new things on the patents. So how that works?
I think that's exactly right. Thank you. Yes, the amendments are narrowing in nature only, limiting the scope. Obviously, you can't expand it or rewrite completely, though. There have been cases, certainly in UK litigation, where we have managed to effectively rewrite the claim in the course of litigation. Very good. Well, thank you very much, everyone. If you join me in thanking the panel.